Was an email to all of you from someone with an anticipatory opposition to the Marriott Hotel application that's coming before you. And it's been a long time since this council has had a big land use application come through it. And so I would, in this instance, you'll be sitting as if this gets appealed, if it's approved and gets appealed and could eventually end up at City Council. You'll be reviewing it as judges. This is called quasi judicial. And so these sorts of contacts and communications outside the context of a hearing, they shouldn't happen. You shouldn't encourage them and it's not even helpful for the people who do this because their comments aren't going to be part of the record if they don't communicate with you through a hearing process where it will become part of the record. And it's akin to a litigant in circuit court, buttonholing the judge at the grocery store about their case. So that's why it's not a policy matter for you. It's not a policy matter for the planning commission or anyone else. This application will be decided based on the criteria in the code. And that's how it's done. It's not how you feel about it, whether, it's your brother-in-law who's the applicant or a friend of yours. It's whether the application meets or doesn't meet the applicable approval criteria. And you're supposed to decide it based on testimony and evidence that's in the record. Applicants are entitled to that. And so that's why it's not appropriate to, engage in communication with anybody about a quasi judicial land use application that could come before you.
Thank you, Dan.
So I think two things from that. One, if you are getting questions, concerns, comments, refer them back to Dustin Nielsen or you can send them to me. We want to make sure that they get in the right path so they do get to, their comments are officially entered. Planning Commission will see this next Monday. So already they've received a number of comments on this. And then the second, of course, would be some of this could be ex parte communication that you would have to disclose later. So if you have substantial conversations, please document or log them so that you have, if this comes to you a year later, you're not going to remember that substantial conversation you had. So make yourself a log of the conversations you have, the things that have been talked about, just so that you can disclose that and be transparent should this topic come to you later.
And it'll be quicker than a year. We have to whip this out in 120 days. So.
Doug.
Now you said conversations, Abigail. So if we're receiving emails and not responding, does that constitute ex parte contact?
What is that?
If we're receiving emails, though not responding and engaging in dialogue, does that constitute?
It does. An ex parte contact is information you obtain about a quasi judicial matter outside the context of the hearing. So if you get factual information about an application like this one, you would need to disclose that. And so if this comes before you, it may not. I would expect all of you to say, I received this email from Mr. O'Neill, and it didn't contain any factual information that's relevant to the application, just his opinions. That's fine. And I actually include a copy of the email in the record just so it's all clear. And so usually you don't, in these sorts of things, you don't get a lot of factual information. No one's going to kind of grab you on the street and talk about trip generation and, traffic circulation associated with an application. But if they do, that's very factual, could be, and the applicant or anyone is entitled to rebut those contacts and the information you get through them. So that's the purpose of the ex parte contact rule.
Thank you.
Thanks for bringing it up, Dan. For me and others, I'll carry on a bit here. So not hypothetically, in fact, yesterday at church, an individual gets up and says, oh, I'm so worried about this. Our town is just changing and growing. And I mean, there I sat. Mm-hmm. Is that ex parte? Do I make a note?
In theory, but you didn't hear any factual information that's relevant to the application. You just heard somebody's opinion about what they feel about the.
Yes, that is. I heard someone's opinion. That's absolutely what I mean.
Yeah, and so if this comes before you, can say, over the past few months, I've heard people's opinions, the negative opinions about this, and it doesn't affect my ability to decide this application based on the criteria that apply and the facts and evidence in the record.
Great, thank you. I appreciate that. Any other questions for our